Hi, welcome to Chapter 1 of Marriage and Marriage-Related Agreements. We're just going to go through the first part of Chapter 1 to give you a little bit of context before we do a deep dive into marriage agreements. And over the next few weeks, we'll do a deep dive into the rest of the topics as well. So today, we're going to briefly talk about legal concepts of marriage, legislation governing marriage, and family law contracts and related documents. Again, just briefly to give a little bit of footing, and then we'll go into all of this in more detail over the next 3 weeks. So historically, marriage in Canada followed the Christian belief that marriage was between one man and one woman. It was treated purely as a contract that had legal rights and obligations. Because it was a contract, you could sue for breach of promise to marry, which meant that if somebody broke off the engagement, you got to keep the engagement ring. All of this has now changed, but it is important to understand where we started from historically because it kind of shapes the legislation we currently have because it's continually amended, but this was the starting point. Now, marriage is between any two people. It is highly regulated and legislated, not purely a contract. And you are not able to keep the engagement ring if the other person breaks off the marriage if they paid for it. So, or sorry, I should say breaks off the engagement. Whoever paid for the ring gets to keep. Society has two main purposes for marriage. One is to estow rights, and the other is to estow obligations. So rights that you can receive by being married, your textbook says might be tax benefits. In my experience, it's usually not beneficial tax-wise to be married, but maybe there are some tax clauses in there that are beneficial. You are entitled to your spouse's pension, and you can make decisions if your spouse becomes incapacitated. Obligations, the main obligation is that you're responsible for each other's financial well-being. So if the marriage breaks down, then you may be responsible for spousal support obligations, and there has to be a fair division of assets. Initially, only people that were formally married were entitled to those rights and responsibilities, but over time, people that are in a marriage-like relationship have been entitled to more rights and more responsibilities. The development of rights for individuals who live together without being married grew slowly, and now it's marriage-like, so even if they don't live together, it's possible to be in a marriage-like relationship. Most rights that are given to married couples also apply to common law couples. Common law couples are entitled to spousal support and division of property. They get income tax benefits if there are any, and they have the same obligations that married spouses have. In 2003, BC became the second province to legalize same-sex marriage. So all civil unions will be granted to any two people of their choosing. However, religious unions, religious groups still do not have to perform or accept same-sex marriages. So the right to religion prevents the government from forcing religious groups to perform same-sex marriages, but same-sex marriages are allowed under civil unions. So that's all we're going to talk about with respect to legal concepts of marriage right now. There is another short video on the history of marriage that you can watch today as well, and we'll talk a little bit more about this as we go along. Next thing, again, briefly, that we're going to talk about is legislation governing marriage. So first, we're going to talk about two federal acts about entering into a marriage. So the first of that is the Civil Marriage Act that defines marriage as a lawful union of two persons to the exclusion of all others. So we know in 2003, BC legalized same-sex marriage, and then in about 2004, the federal government recognized same-sex marriage by amending the Civil Marriage Act to remove between a man and a woman and change it to two persons. Second, the federal government has the Marriage Prohibited Degrees Act, and in this act is where we find what's called the Table of Consanguinity, and that says who we cannot marry that we're related to. So it may be surprising, but in BC, we are only not allowed to marry lineally, meaning that we cannot marry people in our immediate family, our brother, our sister, half siblings, adopted siblings. You can marry your step sibling, and you cannot marry linearly, which would be your mother, father, children, grandparents. You can marry anyone else. So you may have noticed it didn't say you cannot marry your cousins. So that came to a big surprise to me when I was in law school to learn that, and it has not yet changed. May not fit within our societal norms, but legally you can marry your cousin in BC. Provincial Act. We have a Marriage Act that defines how you obtain a marriage license in British Columbia and what constitutes a valid marriage ceremony in British Columbia. So we're going to go over 4 main components of this, which is the age requirement, mental capacity, consent, and monogamy. So we're not going to go over what constitutes a valid ceremony, but we will go over the requirements to legally enter into a marriage. So age requirement. The parties must be 19 years of age or older to be able to enter into a marriage on their own accord. If they are between the ages of 16 and 19, then they can enter into a marriage if either they have parental consent or the court orders it. So typically you see this if they've become pregnant, even as young as 16, that the parents or court may give permission for them to get married. If you are under the age of 16, then you would need a court order to get married. I don't think those are really granted too much, so I can't give you particulars of that, but parental consent would not be enough if you're under the age of 16. You would need a court order to get married. Mental capacity. People entering into the marriage have to have normal physical and mental capabilities to understand the nature of the marriage ceremony so that they understand it's a legal obligation with rights and responsibilities, and the duties and responsibilities created by marriage. If somebody is intoxicated by alcohol or drugs, they probably still have the capacity to get married. They would only not have the capacity if they didn't understand the words of the ceremony. So if they didn't know where they were, what they were doing, that they were entering into a binding marriage relationship, then if they were that level of intoxication, then they may not have the mental capacity. But if they were just intoxicated to the extent that they understood they were getting married, but they made a bad decision because they were intoxicated, that will not negate the mental capacity requirement. Consent and monogamy. Both parties must give free and voluntary consent to the marriage. So we used to have things called shotgun marriages where somebody would get somebody pregnant and their dad would get a shotgun and say you have to get married. Obviously, that's not valid and binding. People have to be free, voluntarily consenting to the marriage. This means that there's no physical harm being threatened. If it's just that, they're not going to get money unless they get married. They're not going to be entitled to something. There's a lot of pressure for them to get married. That's probably not going to negate their ability to consent. And finally, monogamy. They have to have either been never married, widowed, or divorced in order to get married. So you are only allowed to be married to one person at a time in BC. And so you have to check the box that you've never been married before, or that you're widowed, or that you're divorced in order to get married. Common law relationships. Common law relationships, there's a lot of misunderstandings out there, and I think it's because there's no one legal definition of common law. So your Insurance Act may say you have to be in a common law relationship for 6 months before you're entitled to health benefits from your partner. The Tax Act says that you have to be living together for 12 months or have a child together in order to be considered common law. The Family Law Act says you have to be living together for 2 years, or in some cases just that you have a child together in order to be considered common law. So you really have to look at each area of law that you're dealing with to determine how long the parties have to have been in a marriage-like relationship before they're entitled to the rights and responsibilities of that statute or that contract in the case of insurance. For this course, really the 2-year requirement is what's going to come up over and over again because we're mostly going to be dealing with the Family Law Act, and that's their definition. However, again, it is important to keep in mind that in some sections of the Family Law Act, you can be living together for less than 2 years if you have a child together and still be defined as common law. We have two statutes governing the end of a relationship. So the Provincial BC Family Law Act governs the end of both married and common law relationships, and it gives them, for the most part, the same rights to spousal support, property division, parental arrangements as married couples. The provincial government has the jurisdiction from the BNA Act, if you remember back to legal office procedures, to enact laws regarding a person's civil rights and properties. So under this division of powers, it gives them the rights to govern a lot of family law. There is some overlap. So under that same division of powers, the federal government has jurisdiction over marriages but not over common law couples or property. So they can govern how you get a divorce and flow ancillary issues that flow from that, like parental rights, but they can't do division of property, and they cannot make rules with respect to common law couples. So if you're a common law spouse, you must go under the Family Law Act. If you are a married couple, then you can choose to go under either the Family Law Act or the Divorce Act. But if you need a division of assets, you would need to do the Family Law Act. So I feel like that's probably clear as mud. Don't worry, we are going to spend a lot of time over the next couple weeks talking about the division of powers and the jurisdiction and the different acts. So if just at this point, know that there are both federal and provincial acts regarding the end of a marriage. There's only one act for the end of a common law relationship, which is the Family Law Act, and we will fill in the blanks as we go along. Again, we're going through this very, very briefly so you can have an overall understanding, and then we'll fill in all the blanks as we go along. So the last thing we're going to talk about is family law contracts and related documents. So marriage agreements can be entered into before the marriage or during the marriage. If they're entered into after the breakdown of the marriage, they'd be called a separation agreement. So marriage agreements are before or during the marriage. Common law couples can enter into something very similar, and we would call it a cohabitation agreement. These agreements all set out the rights and obligations during the marriage and at the time of the separation. So our acts, the Family Law Act and the Divorce Act, do set out rights and obligations. However, there's wiggle room, there's vagueness. So often parties, especially if they have a high net worth, they want to have some certainty. And if there's wiggle room, they want it to be to their benefit or to something that's mutually agreeable. So we can put that together in a family law agreement. Federal and provincial laws may limit what the agreements can cover, and will have some allow some power to the courts to make sure that it is just and reasonable and it was entered into without duress. So for example, you can't make any final decisions on parenting arrangements in your agreements. You can put something in there, but the courts always have the right to override any court order or any agreement regarding the parental agreement arrangements, because those things change over time, and they want to always make sure that at any given point, they're looking out for the best interest of the child. So the main things that marriage agreements usually deal with is support. If somebody's going to be entitled to spousal support, it'll set out how much that will be, when they would be entitled to it, details like that. It may be reciprocal support, so each spouse agrees to support each other for a specific time or until a specific event occurs. So somebody's going to go to school first and the other person's going to work and support them, and then they'll flip. Even if the marriage breaks down, they could put in an agreement that they will do that reciprocal support regardless of whether the marriage is broke down or not. Separately acquired assets. They may agree that certain property is the sole property of one spouse, so that if there's a breakdown of the marriage, they're not going to divide that acquired asset. So maybe there's a cabin that's been in one spouse's family for a very long time, and they want to make sure that doesn't have to be sold and divided or given to the other spouse. They can put that into an agreement at the beginning, as long as that's fair, that it's going to stay a separate asset of that spouse during the marriage and if there's a breakdown of that marriage. They can also specify what are jointly acquired assets. So maybe one spouse lived in the home for a short time and the other spouse moves in. They may want to specify that this is going to be a divided asset, notwithstanding that this person bought it a year ago, because I'm going to renovate it, I'm going to do contributions, and they want to make sure the courts may have decided the same thing, but they want to have certainty as to the fact that this will be considered a jointly acquired asset, meaning it has to be divided between both of them if there's a breakdown of a marriage, and not leave that to a judge to determine what's a separately acquired asset that one person can keep and what's a jointly acquired asset that has to be divided. So all of that can be decided in advance. A lot of family law agreements still have backing sheets. These are pretty traditional. You don't find them on a lot of other agreements. A lot of people have done away with backing sheets, but you do find them on a lot of wills. You probably did them during your wills class and in family law. For this class, only prepare a backing sheet if you are preparing a court order, because the courts do want backing sheets on all court orders, or if you're instructed to do so. So if you're asked to add one to the back of an agreement, then do so. If you're not given any instructions on it, then you don't need to prepare a backing sheet. You can find examples and instructions on how to do a backing sheet in your family law manual. Make sure if you're doing it for an agreement, you're following the agreement backing sheet, because there are instructions and examples for both the agreement backing sheet and the court order backing sheets, or the court document backing sheets. When you are preparing a backing sheet in paper, you want to staple it as the last page of the document facing outwards. So that way you can flip it over and keep the rest of the contract kind of private and be able to see the pertinent details, what the contract is, who it's between, and who prepared it. In family law, it is very common, if not 100%, it should always be done, to get a certificate of independent legal advice. So again, hopefully you're remembering back a little bit from legal office procedures, but a certificate of independent legal advice proves that each party had their own legal advice, letting them know the obligations and rights contained in the contract before they entered into it. Doing this will make the contract less likely to be set aside by a judge. So if you claim that it was unfair, you didn't understand it, and you go to a judge and argue that, if you have a certificate of independent legal advice that shows you went to a lawyer who explained it to you, then it's going to be hard to argue that you didn't understand it or that it was unfair. The couple should each have their own lawyer, but they could begin by going to one party's lawyer, giving them all the instructions, having them do the majority of the work, and then once it's done, then the other partner just going to an independent lawyer to review it and make sure that it says what they expect it to say and that they understand their rights and obligations, to try and keep the costs down. That's all we're going to talk about at this stage. You do have a lot more slides for today on how to format marriage agreements, more information about marriage agreements. So again, this is just a short little introduction into all of this, and we will do a deep dive into all of the statutes and the agreements over the next 3 weeks.